Hello, welcome to Chapter 3, Emerging Business Ethics Issues. If you recall from reading the book in the chapter, you are aware that ethical issues exist all over our organizations every single day. If you open a newspaper again, you're going to see ethical dilemmas related to businesses around the globe. Let us now continue talking about ethical issues in business. More specifically, we will talk about discrimination that relates to you, me, our colleagues, our coworkers, our superiors, and even our family members at times in the business environment or in the workplace. So what is discrimination? Discrimination on the basis of things like race or skin color, your religion, your gender, your marital status, your sexual orientation, public assistance status, disability, your age, your national origin or ethnicity, your veteran status is illegal in most countries, and definitely in the United States, because these are categories that we consider them to be protected. So therefore, as an employee, as a manager, you have to be very careful not to discriminate against individuals based on these protected categories. Obviously, you shouldn't discriminate at all in any case. However, there is legal discrimination and then there's illegal discrimination. Legal discrimination is basically when you say for a specific job, you know that you need somebody to have a 4-year degree or a bachelor degree in order for him or her to do the job well. So if a 4-year degree is required for this position and people without the bachelor degree apply for this position, then you're discriminating against individuals who do not have a 4-year degree or a bachelor degree. So that form of discrimination is legal because it is based on qualification and you advertise that. However, when you're discriminating based on a person's gender, whether he or she's a male or a female, you give preference to one over the other, even though the qualification might be the same as another individual, then in this case, it would be illegal discrimination. So that's what we call protected categories based on government laws. If you discriminate against them, those are illegal forms of discrimination. So discrimination on the basis of political opinions or affiliation with a union is defined usually as harassment. We don't want to harass another individual either, because harassment can obviously negatively influence the person's thinking in his or her level of productivity in the workplace. As you're making decisions in a business environment, keep in mind that discrimination cases are always investigated by lawyers or the Equal Employment Opportunity Commission, EEOC, in the United States. So anything that seems to be illegal or against the law, don't do it. And anything that seems to be unethical, you have to be very careful and think heavily on what might be the most ethical decision to make before you decide. For the Americans and for managers who are working in the United States, you also have to become aware of Age Discrimination and Employment Act. So the Age Discrimination and Employment Act makes it illegal to discriminate against older workers. The Age Discrimination and Employment Act basically makes it illegal to discriminate against individuals who are 40 years of age or above. So the U.S. Congress and President back in the 60s decided that since discrimination was high toward those individuals who were 40 years of age or above, they decided to consider the age of 40 the starting off an older worker, even though a person who is 40, 45 years of age is not necessarily considered old, but nonetheless, that's when discrimination begins. So the law defines older worker as a person who's 40 years of age or above. And also become aware of the affirmative action programs. So these affirmative action programs involve efforts to recruit, to hire, to train, and to promote qualified individuals from groups that have traditionally been discriminated against on the basis of either their race, skin color, ethnicity, gender, or even religion or sexual orientation in the workplace. So affirmative action programs basically try to provide equal opportunities to all individuals. Affirmative action program does not mean that you have to discriminate against the majority, but it does mean you try to basically encourage those of the minority groups to apply for your organization by creating awareness, by giving them more pamphlets, in some cases by giving them extra points for bringing a diverse view to your organization. In order for your organization to have affirmative action program, the Supreme Court has recommended certain standards. First of all, there must be a strong reason for developing an affirmative action program. In other words, women have been consistently discriminated against, therefore they're not working in your organization. You need more women, and females are not applying, so you need to encourage them, and you need to perhaps provide some training, maybe some skills in interviewing skills, maybe educational opportunities to get certain certificates so more women can come and apply to your organization, and they can be part of your workforce, and obviously they can better take care of the female population of your organization. In other words, they'll bring the female voice so you can gain more market share or more customers if female consumers were not coming to your organization. So you need that diversity of thought. Second, affirmative action programs must apply only to qualified candidates. And third, affirmative action programs must be limited and temporary and therefore cannot include rigid and inflexible quotas. In other words, the purpose of affirmative action programs are not to discriminate against majority, because discriminate against a person who has had nothing to do with the biases of the past is still discrimination, which is illegal, so that's not fair either. So we don't want to reverse discrimination in the workplace, but you do want to equalize the workplace, and you want to provide fair opportunities to all. Another important ethical issue in business is basically the topic of sexual harassment. Sexual harassment is any repeated unwanted behavior of sexual nature perpetrated upon one individual by another. Usually, if one individual is in a higher position and he or she is basically making sexual advances toward a lower ranked individual, that is when the lower ranked individual cannot always say no, so it puts the person in a very, very difficult position. But sexual harassment can take place obviously at any rank, even when two individuals who are at the same level. One is basically making sexual advances that is unwanted and repeated, that is sexual harassment. So sexual harassment can be verbal, visual, written, or even physical in nature. It can occur between people of different genders or those of the same gender and different ranks. The law is basically primarily concerned with the impact of the behavior and not necessarily the intent of the person. So if the behavior of the person is intimidating and basically making the other person feel very, very unwelcome and nervous in the workplace, that is considered sexual harassment. And sexual harassment can lead to a hostile work environment. So a hostile work environment has three different criteria. In this case, the conduct must be unwelcome by the person. Second, it should be severe, pervasive, and regarded by the claimant as so hostile or offensive as to alter his or her condition of employment or behavior in the workplace. And third, the conduct was such that a reasonable person would find it hostile or offensive. So we need to be very careful to make sure our employees do not experience and work in a hostile work environment. And keep in mind that employees need not prove the harassment seriously affected his or her psychological well-being or that it caused an injury. The decisive issue is whether the conduct interfered with the victim's work performance. So if the person could not work, could not focus well, then that is considered a hostile work environment. When it comes to sexual harassment issues in the workplace, we also have to be concerned about dual relationship. Dual relationship could be a personal, loving, or sexual relationship with someone with whom you share professional responsibilities. If the sexual advances in any form are considered mutual, then consent is created. However, unless the employee or the employer gets something in writing before the romantic action begins, consent can always be questioned. Regarding dual relationships, if the sexual advances in any form are considered mutual, then consent is created. However, unless the employee or employer gets something in writing before the romantic action begins, consent can always be questioned. So again, be very, very careful. This is why many companies have laws to where if two people get involved in a relationship, then one of them have to go to a different department or retire from this organization or from this department. So make sure you have policies that are obviously fair to everybody, because human beings are human beings. So sometimes people fall in love. Make sure your laws are fair to everybody. Just because somebody falls in love with another person who works with him or her does not mean he or she is a bad person or he or she is creating a hostile work environment for the other. But have some rules that make sense, so this way both individuals who have good intentions in this relationship can be protected and it doesn't present any problems with other employees in that environment. So good luck being ethical in all cases. Remember, ethical behavior is a skill. You need to please evaluate and improve your ethical muscles every single day. Good luck.